So what do you do if you're getting pushed around by a bully attorney in a deposition? I've had some comments and requests for depositions and how to conduct yourself, and it's a very wide topic. I'm going to be putting a course together that will cover all aspects of it, but let me just give you a couple of thoughts about what you do. If you're a litigator and you do depositions, you are going to run into these folks. I guarantee it. Now, today, there are more remedies for deposition, discovery abuse that there weren't in the old days. I remember the first deposition that I ever conducted, and I was faced with a very seasoned trial lawyer who was just, the quintessential example of abusive. Now, outside the deposition room, he was a nice guy, and we actually became friends later. But inside, he was a bully. And I remember asking the first question, and he made a comment. He said, "That is the stupidest question I've ever heard." Now, why did he say that? He's trying to throw me off. That's what he was trying to do, and he was successful. I didn't know what to do. And throughout the deposition, he just made those kind of snide remarks. Completely improper, but I didn't know, and I got pushed all over the place. You don't have to put up with that these days. There are remedies in the rules that allow you to bring this kind of attention to the court and to get some remedies, and they can be very harsh. But let me give you a couple of pointers. First of all, understand this, that a deposition is absolutely no different than a trial in a courtroom, with the exception is there's no judge present. And that's where the abuse comes from. Lawyers do things in depositions that they would never do in a courtroom. Let me give you an example. One of the things they try to do is coach the witness. So their client is being examined, and there's a question that's being asked, and they're kind of concerned about that question, and they'll say something like, "Oh, if you know." Okay. Now, in a courtroom, if your client was being examined, and there was a question that came from, would you stand up in a courtroom with the judge there and say to your client, "If you know"? Oh, you wouldn't, and if you did, it would be the last time you did that. It's completely improper. But that's something that you're going to be encountered with, and you have to put an end to that immediately. You have to let that lawyer know, no, we're not doing that. And you come right out and say, "Please stop coaching the witness." You do it on the record. And if they don't stop, you say that every single time. Why? Because you're building a record. If you're going to take this issue to the judge, you want to build a record. And so the court, if you're going to make a motion of some kind for discovery abuse, you want to attach that transcript that shows that this lawyer repeatedly tried to coach his witness, and you repeatedly objected to it. Now, what happens if it continues and it gets to the point where it's clearly obstructing your ability to conduct your deposition? The first thing I would tell you to do is see if you can get a judge on the line. Whoever is in line in terms of trial judges, call and say, we're conducting a deposition. I'm having an issue here. Could I speak to Judge so-and-so? A lot of times the judge will interject and bring an end to that. But even if that doesn't work, the more extreme examples would be if you really cannot conduct, and this is pretty rare, I've done it on a couple of occasions, you just cannot continue with the deposition because the other attorney is obstructing you. Not only is that lawyer coaching the witness, but he's telling the witness not to testify. Now that's really serious abuse. He can object, or she can object to the form of the question to preserve that for trial, so that if it was an improper question, it can't be elicited at trial, because typically what the lawyer will say, object to the form of the question. Now, what is he saying? Is I'm preserving my right to object to the form of this question, but the witness can go ahead and answer the question. It's a deposition. It doesn't mean that that testimony is ever going to see the light of day in a trial. But you have to presume you're right, and you do that by saying, I object to the form of the question, or however you want to phrase it. But the witness is allowed to answer the question. If you have a situation in which the lawyer is saying, I'm directing my client not to answer that question, that's pretty serious. Now, when is that proper? Well, usually if you're talking about privileged communications, if you're trying to protect your lawyer-client confidentiality, yes, you can tell your client, in my opinion, you're asking him a question that is protected by the attorney-client privilege, and so I'm going to direct my client not to answer that. And we'll get into that in other videos, but the attorney-client privilege sometimes is misunderstood. If you ask the witness, did you meet with your lawyer before today? Are you asking an attorney-client privilege? No. Now, if you ask him, what did you talk about when you talk to your lawyer? Yeah, that's a privilege, and you are within your rights to say you're asking for privileged communications, and I'm directing my client not to answer those questions. But again, those are rare circumstances. But I think the thing that I would tell you, when you're faced with this lawyer, is you have to nip it in the bud. If you don't object right away when these improper tactics are being used, you're going to be in for a long deposition. And as I said, you want to lay a foundation so that when you do seek remedies from the court, you'll have a good record.